Hi, this is Andrew Winters, one of the partners at Cohen and Winters, and I want to talk to you today about one of the most frequent questions we get. What are our fees and how do we charge? So, with lawyers, there are three different types of fee agreements. There's the hourly fee agreement, a flat fee agreement, and then the third type is the contingency fee agreement. Now, the hourly fee agreement is probably the most common, or at least historically, the most common type of fee arrangement that lawyers charge. And it's basically by the hour. So the lawyer bills for time spent working on the case. The rates of the lawyer can depend. Right now, as of this video, which is 2021, the rates for our lawyers range from $260 to $330, and the rates for our paralegals range from $100 to $130. And of course, those rates are reviewed periodically, usually about once per year, due to the cost of living. So with the hourly fee arrangement, typically what we do, what most law firms do, is based on the type of case, they collect a retainer. So the retainer is not the fee itself, but a deposit towards the fee. And then the retainer funds are placed inside of the attorney's or the law firm's trust account, also often called an IOLTA account, which stands for Interest on Lawyer's Trust Account, a special type of trust account. And when the law firm, so when we invoice for our time, typically monthly, we'll take the amount of money that was put into the retainer and transfer it to ourselves as it's now earned. Then we'll issue a statement to the client showing how much we've invoiced and how much we have left on retainer, that is, how much is left in the client's trust account. We'll also typically set what's called an evergreen amount. Now, the evergreen amount is the minimum retainer requirement. So that's the amount that we ask the client to keep on retainer so that we know we have enough money to pay for our services. Now, those amounts can vary, but they're going to be based on the scope of the case that we're involved with. Because with lawyers, what many people don't realize is once we file an appearance with a court or agree to take on a piece of work with the court system, we can't just stop working on the case because the client hasn't paid us. We have to get permission from the court. So we need to make sure we have enough funds in our retainer, in our trust account, that will be paid through the course of the case. The hourly fee agreement is most often used for family law cases, for felony level criminal cases, and for general civil litigation if we ever take on certain types of civil litigation cases. It also may be used for miscellaneous types of matters that are hard to pin down the exact amount of work that we will have to engage in for the case. Now, the advantages of the hourly are, in some ways, it's the most accurate way to the firm to bill and for the client to pay, because the client simply pays for the services that were used. The disadvantage is that many clients, in fact, probably almost every client, prefers to have a fixed amount that they know they're going to have to pay. And the law firm, us, in some ways also wants that, because then, while we're still going to keep track of our time and be able to account for our work, we don't have to incur the burden of trust accounting and regular invoices and trying to collect money. We would just have the amount set and then we would just do the work. The problem is it's very hard to scope the work in a lot of these instances, meaning if we take on a litigation case, we don't know how involved it's going to be. We don't know if the other side is going to hire a lawyer. We don't know how hard the other side is going to fight. We don't know if it's going to settle quickly. We don't know if it's going to go all the way to trial. So it's really impossible, especially in a family law case, for us to know how much total work is going to be involved. We might be able to set a budget. In fact, we try to set a budget at the outset, but to set a fixed flat fee is very, very difficult for us to do in those cases. And therefore, we get a set retainer with the evergreen requirement. Now, typically for divorce cases, our retainers are going to range anywhere from $4,000 to $6,000, $7,000, often $5,000 is a starting point for contested divorce cases, and we have the retainer minimum anywhere from $3,500 to $5,000, again, judging on how involved the case will be. And we also state in our fee agreement that the law firm retains the right to adjust the retainer requirement based on the status of the case. So if the case starts out seemingly not contested and then it ends up becoming contested or more heavily contested, or issues come up that we didn't originally anticipate or weren't predicted, we could raise the retainer requirement to reflect the greater amount of work that we think we're going to have to be doing. On the other hand, if the case is winding down, say it's settled or it's close to settling, we just have to finalize the documents, then we can release or lower the retainer requirements. We don't have to get as much because we're not expecting to do as much work for the rest of the case. The point being that the retainer and the amount in our trust account is refundable at the conclusion of the case. So any amount left in the retainer when the case is completely done and no more work needs to be done by the law firm is returned to the client. So again, a lot of people get confused. They think that the amount of the retainer is a fee that the law firm takes immediately. That's not entirely true. It's just held in the trust account and used for the fee that is ultimately billed to the client by the hour. The alternative, as I've kind of alluded to, or the primary alternative to the hourly fee, is the flat fee. Now here with a flat fee, the law firm states that there will be a specific amount of work done, usually one case, which is defined as a case in one court for a certain type of charge or a certain type of matter, and there will be one fee that's collected up front. We hold it in our trust account until the case is completed, but it's a fixed amount that is considered earned upon the completion of the case, or sometimes in segments of the case if it's a longer case, that we earn portions of the fee once each segment of the case is completed. Now the advantage of the flat fee is, as I indicated before, what clients and often the law firm prefers, which is that it's a known amount. We use flat fees a lot for DWIs, driving charges, and misdemeanor charges. We use them for a lot of estate planning and some other petitions to annul, or what New Hampshire calls annul, which many states call expunge a conviction. In all of these cases, we have a pretty good sense of the amount of work that's going to be involved, or at least on average, how much work will be involved over the course of these cases. So what that means, for example, on a DWI case where we may get, depending on the type of the DWI and the court that we're going to be traveling to, anywhere from $3,000 to $5,000, the amount of work could vary. Some cases are plea bargains, some cases are trials, some cases have multiple court appearances, some cases only have one. But on average, we have a very good sense of how much time we put into these cases so we can accurately price them as a flat fee for the clients. And we wish we could do this on felony cases and divorces, but it's just proven very, very difficult or impossible for us to do, so we rarely are able to offer flat fees on those kind of matters. Now, the final type of fee agreement is what we call a contingency fee agreement, and that's basically a type of flat fee agreement. But the difference is the amount of the flat fee is not fixed in advance, but it's based on a percentage of the amount of money collected on the case. Now, the rules of ethics limit when contingency fee agreements are allowed. It's usually only allowed on collections types of cases, which for us and for many law firms usually means a personal injury case like a car accident, where we don't know in advance how much money we are going to be able to collect for the client, if any. And here's where you hear these kind of cliche, corny expressions like, we don't get paid unless you get paid. But it's true. The point being, the client doesn't have to pay the law firm any money in advance or any money at all if they don't win the case. So that's a huge advantage to clients who may not have any money on hand, and to clients who don't want to take the risk of losing the case and have to actually pay money and not get any back, which would add insult to injury if you're the victim in a case. So we take on the risk of losing the case, and in those instances we often put in a ton of time, tens of thousands of dollars worth of time on the law firm's part. We also advance expenses. In order to get records, we have to pay money. Sometimes we employ private investigators and expert witnesses. If we file a lawsuit, we pay the filing fee. We have to pay for a transcriptionist for depositions and so on. So in addition to our own time, we also may advance out-of-pocket expenses to third parties. And we take on the risk in those cases that if we lose the case, and we try not to, but every law firm loses cases, let's be honest. So if we lose the case, then not only do we not get a fee, but we actually lost money. On the other hand, the advantage for us is that if we win the case, we get a percentage, and that percentage may very well be higher than what we would have earned by a pre-negotiated flat fee or by the hour. But we are taking on the risk, and we're taking on the delay of the payment, that we have to advance all these expenses in our time, and we may not collect anything for, in injury cases, many months or sometimes years. So the clients appreciate that because they can get a lawyer regardless of their financial status, and we can start working on the case immediately, and they're secure in that they don't have to pay anything up front. And it's the one time in life where the higher the fee you pay, the more happy you are, because it meant you also get more money. So again, to summarize, those are the three types of fee agreements that we typically use. The hourly fee agreement, which is used most often for family cases and felony level criminal cases. The flat fee, which is most often used for misdemeanor criminal cases and DWI and driving cases. And then the contingency, which is most often used for personal injury cases. We hope this has been helpful, and if you have any questions, don't hesitate to give us a call. Again, my name is Andrew Winters with Cohen & Winters. Thank you.